So it's my privilege to introduce, as the panelist, or as the chair of the panel, our three panelists today, and I'll introduce them serially, starting with Professor Watts next to me here, and we'll give them each about 20 minutes to make some remarks, and my job is to dispatch them instantaneously if they exceed by more than 30 seconds their allotted time. Associate Professor Watts earned a bachelor's degree in international affairs from the University of Colorado in 1992, and as a William & Mary grad myself, I'm proud to say he was a graduate of the Marshall Wythe School of Law in 1999 at William & Mary. He also has a master in legal studies from the Judge Advocate General School in 2004, and he served while he was in law school as notes editor with the William & Mary Law Review. He's most recently taught as Associate Professor of International Law at the Judge Advocate General School and has been a lecturer at the University of Virginia School of Law. He served as Judge Advocate General in the United States Army from 1999 to 2007 and attended law school under the Army's funded legal education program. Prior to selection as a JAG, he served as a regular Army officer in the Armor and in the Tank Battalion. So it's our privilege to have Professor Watts kick us off this morning. Sir.
Thank you, Dr. Lewis, for the kind introduction. I appreciate that. And also thank you to Dr. Barrett for the invitation and for including me in this terrific event. I'd also like to thank him for the topic choice. As a law of war specialist, business has been pretty good for the last 10 years, I'd say. But unfortunately, most of the invitations have been quite narrow. We've been talking about detention, military commissions, and torture for most of that period. And so I have to say, the number one reason I like talking about cyber operations is that it is not detention, it is not military commissions, and it is not torture. It has nothing to do so far, with any of those topics. I don't have to think about them at all, and I really like cyber for that reason. I also cringe sometimes when the time that I spent on tanks is mentioned. They were quite technologically complex when I was on them, and lest anyone get the wrong idea about my own technological prowess, I always like to add this caveat. I think the most commonly uttered phrase on my tank was, "Sir, don't touch that." So, having laid out all the cards on the table, so to speak, about my technical prowess, maybe we'll go forward then. So my assignment on the panel was to outline the legal regime, specifically the legal regime that regards when states may lawfully resort to force in their international relations. And then it was I was asked to perhaps translate some of that to the cyber realm, or to forecast or to describe how that operates during cyber operations. So I'll do that, and then what I'd like to do after that is to perhaps give a snapshot of some emerging trends as I see them. I'll refer in particular to a paper that I wrote for the Naval War College about a year ago entitled Low Intensity Computer Network Operations. So first, to start, just a few words about the law. So accounts in this area vary wildly. It's really difficult to get a room of international lawyers together and have a consensus story of how this law works or what its contents are. You know, entire careers are built on the ambiguities here. Scores of tenured professorships, I think, are owed to the ambiguities that you find in this area of the law. But for today's purposes, I think what I can do is account for three major provisions of the law of the resort to force by states. So I'll take you first to the United Nations Charter, and I'll take you specifically to Article 2 of that document. On its face, this may be one of the most significant concessions states ever made to treaty law, or one of the greatest surrenders of sovereignty that was made. This is the provision of the Charter that prohibits states using force, threatening or using force in their international relations. It's widely regarded as an improvement over previous attempts. There were early 20th century attempts to do roughly the same thing, but far less successfully and far less specifically. But despite those improvements, there's still ambiguity here, and this provision is still a source of a pretty persistent debate. And this is with reference to the scope of this term, use of force. So what's included there? What's not included? What can a state do and not run afoul of this norm? What can states not do under this norm? There are some areas that are clear. So first, the use of military force seems clearly included in this. So we can include things like invasions, we can include bombing campaigns, we can include sinking a ship, I suppose. But the debate really surfaces when we go broader than that, when we look outside of traditional military uses of force to other forms of coercion. So it was suggested by developing states later, after the treaty was adopted, that maybe other forms of coercion ought to be included here and therefore prohibited to states. That would include political force or economic force, perhaps, or even espionage. Each of those, in turn, has probably been rejected by the majority viewpoint. The majority viewpoint today is probably that political force, things like perhaps propaganda, do not rise to the level of a use of force that would be prohibited. Economic measures as well. There was a proposal to include economic measures explicitly in Article 2, and that was rejected by states at the drafting conference. So things like an embargo would not rise to the level of a use of force. And then finally, espionage has traditionally been excluded from what most lawyers would consider a use of force under Article 2. The remainder of this architecture or the remainder of this legal regime is probably best captured then in the two exceptions that you find to Article 2. So if Article 2 is our baseline for the norms against the use of force, we find a set of exceptions that follow in the Charter. The first is Article 39. This article is really, I think, reflects the highest hopes, or perhaps the dreams, of those that envision the United Nations collective security arrangement. 39 is probably the depository for whatever states gave up in Article 2. If it really was such a great surrender of sovereignty, where did that power go? Well, it went in Article 39 to the 15-member United Nations Security Council. The Security Council under Article 39 is permitted to authorize states to use force. So this would be the first exception to it, and it's probably the essence of this collective security regime. Well, if Article 39 is the dream of the Charter, it's probably an unrealized dream, as most of us know. Political considerations have paralyzed the United Nations Security Council for a very long time, indeed for most of its existence. And so if 39 is the dream, I'd say that the second exception, which is found in Article 51 of the Charter, is probably the reality of the situation. That there's no way you get this great concession to treaty law or this surrender of sovereignty that we find in Article 2 without a provision like Article 51. Article 51 relates to self-defense, and it permits states to use force or to respond with force to armed attacks. So if our first term of art was a use of force, as described in Article 2, the second term of art that you really want to keep your eye on in this area is this term armed attack and its relation to self-defense. Now, like use of force, it is also the subject of intense debate. However, generally, I would say most international lawyers probably agree that when we use the term armed attack, we're describing a narrower set of events than those events that qualify as use of force. I was glad to hear that I wouldn't be the first person to talk about a Venn diagram. Mr. Clark referred to a Venn diagram with his CHEW acronym. I've always thought of it in similar terms, that if we envision a larger circle, and I'll also agree that one of the nice things of leaving government service is to leave PowerPoint behind. I've done that too. But look, you can all picture this. It's fairly simple. We could have a large circle that depicts graphically what we would regard as a use of force, and within that circle we might sketch out a smaller circle that represents those actions that could qualify as an armed attack. They are generally the more grave instances of use of force. There's an ICJ case that sketches some of this out. Okay, so if that's our sketch of the law, how does this work in cyber operations? Or maybe even more fundamentally, does it work? I think there are some that say it simply does not work, that these are now archaic terms, that the cyber context could never have been envisioned by the drafters of the charter. So does this stuff really work in cyber? And I'll give you the lawyer answer, of course. Well, you know, it depends, right? So I think it's clear that some cyber operations do rise to the level of use of force. So some cyber operations would run afoul of the prohibitions that we find in Article 2. These are cyber operations that are most analogous to military force. And I think we find confirmation of this view in a number of the emerging national cyber operations policies. A number of states, including our own, have begun to issue statements as to what they would regard as a use of force, and have begun to translate cyber operations into this legal realm, or into the terms of art that we find in this legal realm. The prime example for me of a use of force in cyber operations would be control of a network. So if a state were to use cyber means to force its way into a network, to gain control of that network, and perhaps deny the operation of that network to another state, I think you would get many international lawyers who would concur that, yeah, that's probably a use of force, and that would be prohibited under the United Nations Charter. Now, examples of armed attack. Can we translate this term armed attack to cyber operations? I think it's also clear that there's some agreement among international lawyers that there are currently cyber events that would rise to the level of armed attack. These are, I think, the examples of cyber operations that capture the popular imagination, or that you find in media accounts. This is what my mom emails to me about cyber operations. Yeah, Mom, I know. I think about this stuff too. So these are attacks like the attack on the electrical grid of the eastern seaboard of the United States, right? Or this is the scenario where someone uses cyber means to gain control of the flow of a dam, and they release too much water and it causes destruction downstream. These are the scenarios like the attack on an air traffic control system that causes planes to crash. What unites these examples, and what I think allows most lawyers to conclude that they are more grave than uses of force, they are that smaller circle of the Venn diagram, they are armed attacks, is the destruction that results from them, that they have produced physical violence, harm to property, injury, or lethal consequences to persons. Mr. Clark's relation of the Stuxnet virus may be one of the clearer examples that, yes, cyber can actually do this now. It can produce these real-world kinetic effects that we have traditionally associated with armed attack. But the point I'd like to make, or the question I'd like to ask, is if the task is to determine the extent to which the regime for regulating the use of force is adequate, if that's our task, and if we're trying to marry that up to cyber operations, are the examples that I just gave really the right ones? Is that where we really expect to find the seams or the cracks in this legal regime? Reviewing some of the emerging literature on cyber strategy leads me to think that perhaps that attention to these major events, attention to the cyber 9/11, or attention to the cyber catastrophe or Pearl Harbor is maybe misplaced. That if that's getting the lion's share of the attention, we may need to adjust from that. There's a growing literature within the cyber strategy community. So, you know, as a guy who writes and thinks about the law in this area, I've tried to branch out, understanding my technical limitations, and tried to understand what cyber strategists are thinking about these days. Well, there's a growing literature in this area that seems to emphasize low-intensity computer network operations. What's really worrisome isn't so much the cyber catastrophe, because the likelihood of that is actually quite small. Mr. Clark probably made that point quite well. That what we ought to be thinking about are these cyber pinpricks, if you will. In the paper that I wrote, I borrowed the metaphor of the death of 1,000 cuts, that strategists seem to regard this as the more likely and perhaps even the more dangerous future of cyber operations. Well, why low-intensity cyber operations? Well, the impression I got from reading their materials is that many of these cyber strategists took their inspiration from counterinsurgency, that they were thinking about about how kinetic warriors were focused on counterinsurgency operations or low-level conflicts, small wars, and thought, well, is this going on in our community? And they seem to conclude that it is. Well, if so, what's so attractive about it? Why not just go for the big knockout punch in a cyber operation? Well, there are a few reasons, it seems. The first is probably technical. These small-scale or pinprick cyber attacks seem to be more technically feasible. If you have done some reading on the Stuxnet virus, if any reliable attribution can be made in that attack, if most pundits or media outlets are guessing that this was the work of a sophisticated state actor, that's because it took immense resources to do an attack like that. And by comparison, low-intensity attacks are relatively easy to do. They are not technically complex, and they can be done on the cheap. The second reason why low-intensity conflicts might be, or attacks might be, attractive is from a strategic standpoint. The first is that they might more easily confound attribution. That is, if you're doing something that just about anyone has the capability of doing, you're not helping your target out, you're not helping your target narrow their attribution work. Secondly, low-intensity attacks, I think if they're ideally carried out, can do a lot to frustrate correlation. That is, if it is an attack of 1,000 cuts, the victim of the attack doesn't even realize he's being attacked. What the ideal low-intensity campaign really looks like is a series of unrelated events. The target isn't able to tell that this is a coordinated effort to secure some national security advantage or some advantage in the arena of international relations. That no, just all these annoying things keep happening to me. And I think ideally the low-intensity attacker pays some attention to making them diffuse in some sense, that there are not patterns to these attacks. They just seem random and unconnected. Finally, I think the advantage that low-intensity cyber operations offer to attackers is that they might evade response thresholds. That by not rising to a high level of damage, you can run just below the consequences that trigger action from your target, or get your target to sound the alarm. In a related sense, I think Mr. Clark's points about some of the problems of interagency coordination can be exploited by a low-intensity computer network attack. If you are riding the seams between his acronym of CHEW, if what you're doing looks sort of like warfare, looks sort of like espionage, and maybe looks sort of like crime, but not definitively like any of them alone, you might frustrate the opportunity or the efforts of agencies to figure out who this belongs to. And so again, you can evade response structures through low-intensity attacks in the way that you might not be able to with the high-intensity version. So finally, well, to sum up, so they are. I think low-intensity attacks are strategically attractive, they are tactically attractive, and they are probably as well economically attractive. Are they legally attractive? How do they work under that regime that I sketched out at the very beginning of this talk? Well, if you're already familiar with the legal regime that I described, or even if you were thinking ahead as I was describing it, you may have developed the notion of a response gap. There is in that legal architecture a response gap, and it refers to what states are permitted to do in response to each of those terms of art that I described. What can a state do when they suffer a use of force? The large circle of our Venn diagram. What can a state do when they suffer an armed attack? The answer to armed attack is quite clear. When a state suffers an armed attack, they are freed from the prohibition on the use of force. States may then resort to all necessary means or whatever means that are necessary and proportionate to countering that threat. What can they do in response to use of force? Well, this is unclear. The majority viewpoint is probably, at least on its face, a view that says states may not respond with uses of force to use of force, that the answer to a use of force is action by the Security Council, that it is only armed attacks that free states from their obligation not to engage in uses of force against one another. Certainly some measures are available to states, countermeasures are available, measures that do not themselves rise to the level of use of force can be undertaken in response to a use of force, but not a use of force itself. So this is the response gap that many lawyers refer to in describing this situation. Ultimately, the question I suppose we have to ask is, well, can low-intensity conflict, can low-intensity cyber operations exploit that gap? Can you run just below the level of armed attack and therefore tie the hands of a state, prevent a state from responding effectively to your attack? Can you run just below the level of use of force? It seems that you can, and there may be a few examples of that. Communications disruptions, I think, are a great example of a low-level intensity attack that would not, under most lawyers' views, rise to the level of use of force and certainly wouldn't rise to the level of armed attack. I'll loop back here just quickly to the Estonian incident. So the Estonian incident, as related by Mr. Clark, met with a lot of hyperbole. It met with strong political statements. It met with a reaction by NATO. There were many states that in the immediate aftermath are using words like attack. But when we slow down and when we actually apply that model or that attack to the model that the United Nations Charter provides, I think we get a very different result, that in fact it wasn't an armed attack, not even close to an armed attack, and nor was it probably a use of force in most lawyers' minds, that this is just a great example of one of these attacks that manages to slip through that response gap that I've described. You know, I suppose the question is not whether cyber operations fit within the architecture. I think the better question may be, you know, do they fit in a way that states find acceptable? What will states do? Mr. Clark gave us his guess that, you know, were Estonia to play itself out again, he envisioned a very different response from states. I suspect the same is true, that were Estonia to happen to a more powerful state, were it to implicate more members of a collective security arrangement, that we might find a very difficult question posed to this security regime that we find in the United Nations Charter.
Thank you, Sean, so much. We'll continue down our table here to our next panelist, Lieutenant Colonel Walter Gary Sharp, United States Marine Corps retired. Upon retiring after 25 years in the Marine Corps, Dr. Gary Sharp now serves as Senior Associate Deputy General Counsel for Intelligence at the U.S. Department of Defense. He's responsible there for providing advice on international and national security law issues related to the worldwide activities and operations of the U.S. Armed Forces. A noted and published authority on national security law, conflict resolution, and cybersecurity, his current responsibilities include providing legal advice on international and U.S. domestic law related to the National Security Agency, defense intelligence collection, information and cyberspace operations, full spectrum computer network operations, critical infrastructure protection, terrorism and counterterrorism, law of war, rules of engagement, and deployment of forces. I think that about covers everything we're interested in here today. He's the author of several books, and most recently, the UN Peace Operations, Cyberspace, and the Use of Force, Just Pacchiari, Emergent Legal Paradigms for UN Peace Operations in the 21st Century, and Democracy and Deterrence, Foundations for an Enduring World Peace. Pleasure to have Colonel Sharp with us today. Sir.
Thank you. In case I drift off as I'm talking today, when I generally look that direction, it's probably because I'm remembering the days in July and August that we practiced parades on that field, or maybe it was when I was marching off to Merritt's. I don't remember exactly which, off over on the fields across the river from us. But I have listened to Mr. Clark speak probably since the early 90s on issues of cyber and cybersecurity before we called it cyber and cybersecurity. And he's consistently one of the speakers that I believe is always on the mark. And that was true again this morning. What I would like to do is to kind of build upon some of the things he said about the role of the Department of Defense by explaining to you what I see as the roles and the responsibilities, and we can also talk about the authorities of the United States Department of Defense and the cybersecurity of the United States. And there are four categories, four notional categories. There's many ways that we could look at this, of course, but I've broken them down this way, and I think it's an easy construct to kind of look at. First role for the Department of Defense is the role and responsibility and our authority to protect and to defend DoD information systems. This is like any other authority that any other department and agency has to protect their own networks and their own information infrastructures. This is our primary role. It is DoD's primary role to defend DoD networks. That makes a lot of sense. The legal authority that is there is very robust. I can give you a list of 20 to 25 different statutes and other authorities that gives the authorities to the Secretary of Defense as well as to the Chief Information Officer for the Department of Defense to defend our own network. But what we're talking about is all network operations, internal network operations, the information assurance, intrusion detection, and those types of techniques that Mr. Clark referred to. The second group of roles and responsibilities is, let's look at our role, our responsibility to protect and to defend non-DoD information systems. That's the rest of the federal government, that is the private sector, etc. We have a support role. The Department of Defense has a support role in defending non-DoD information systems. As was discussed earlier today by Mr. Clark and I think the NSA employee that's here, we can use the primary responsibilities, authorities that NSA has to provide technical support to the rest of the federal government because it has a mission under executive order for information assurance for national security systems, and also can look at the Economy Act, but the Department of Defense provides a support role to the Department of Homeland Security or to any other federal agency with respect to protecting a non-DoD information system. And through DHS, we can provide that expertise through and to the private sector as well. Then there's a third notional category, and that is our role under emergency authorities of the President. We could serve a primary role or we could serve a support role. It really depends upon the situation, and most importantly, it depends upon what the President decides he wants our role to be under his emergency authorities. Not very well developed statutory responsibilities here. Most of these types of emergency authorities are toward obviously the non-cyber type of authorities, where we're talking about the Stafford Act or other types of assistance that we provide in cases of national emergency, hurricanes, and natural disasters, and those types of things. And then there is the fourth category. Remember, the first is DoD protects its own systems, primary role. The second role is a support role where we support DHS to protect non-DoD systems. The third could be primary, could be support role for emergency activities. The fourth category is the Department of Defense's role in defending the nation. This is our primary role. It's our primary responsibility. We have clear constitutional authority under the President's authority to defend the nation. It's not very clear what that role is going to be and what that role is today, because that is a policy decision. It's a decision to be made by the President on the advice of his cabinet, but we have ample constitutional authority for the United States Department of Defense to defend our nation. Okay. Now, I'd kind of like to use that as a segue to kind of build upon Sean's remarks about jus ad bellum. The contemporary jus ad bellum, the law of conflict management, as Sean described, consists of 3 articles of the UN Charter. Article 2, paragraph 4, Article 39, and Article 51. I think one of the points where I wasn't sure if this was your opinion or an opinion that you were sharing that other academics have, but the U.S. government does not see that there is a response gap between Article 2, Paragraph 4, and Article 51. There is no gap in our authority, our responsibility, our right of self-defense to defend our nation. The UN Charter does not set up a construct where another country could unlawfully use force against the United States, and we have no right of self-defense until it reaches some magical point over here that we would call it then an armed attack. So the U.S. government position is that Article 2.4, use of force, Article 51, armed attack, is the same threshold in international law. The reason why you see two different phrases, two different apparent thresholds, is that there were 6 different drafting groups for the UN Charter. There was a different group for the first few sections, such as Article 2, Paragraph 4, and yet a different group for Article 51. They ran out of time, and there was not a conforming convention at the end to look at the consistency of the terminology that is used throughout the UN Charter. Article 41, okay, so then the question is that Sean addressed, and that I'd like to build upon, is what is a use of force under international law in cyberspace? If you look at 2 more articles of the UN Charter, it begins to give us a little bit of a flavor of what is a use of force. We talked about Article 2, Paragraph 4, Article 39, Article 51 for our thresholds and when a state may use force in self-defense or when authorized by the Security Council under its coercive authority under Article 39, under its Chapter 7 authority. But that is really, the UN Charter is really the only text that's in international law that gives us any guidance as to what a use of force is. So if you look at Article 41, it says that the Security Council may decide what measures not involving the use of force, not involving the use of armed force, are to be employed to give effect to its decisions. And then they give several examples. These may include complete or partial interruption of economic relations and of rail, sea, air, postal, telegraphic, radio, and other means of communications, and the severance of diplomatic relations. So that gives you some examples of what is not a use of force. Article 42 tells you, should the Security Council consider that the measures in Article 41 are inadequate, or would be inadequate, or have proved to be inadequate, that it may authorize such action by air, sea, or land as may be necessary to maintain international peace and security. And it gives several examples there as well. Such actions, which would be a use of force, would include demonstrations, blockade, and other operations by air, sea, or land forces of the members of the United Nations. So I am sure everybody sitting around the table is thinking, well, that really cleared it up for me. But that is the starting point of looking to see what is a use of force or a threat of use of force under international law. What each of you should find on your tables is a chart, a one-page chart that looks something like this. Actually, I don't think my colleagues up here have one either. But there should be plenty on the tables to pass around. What I've tried to do here, and I have given lectures as long as 8 hours on this one page. I will stick to my 20 minutes today. But what I've tried to do is to operationalize and to try to give some notional concept. One, what is a use of force or a threat of use of force under international law, but also how the United States government implements that within the Department of Defense. So a couple of other points. Article 51 recognizes the right of self-defense. We talked about that. But the customary right of self-defense that Article 51 recognizes also includes the right of anticipatory self-defense. We don't have to wait until after we're attacked to respond. We can respond ahead of time. There are a number of jurists in the international community that says, unequivocally, absolutely, there is no such thing as a right of anticipatory self-defense. However, when you read their work, after they make such a bold, unequivocal, all-encompassing statement, they will say, however, you don't have to wait until you're attacked to prevent the attack or to respond. So the real issue is, even among the folks who say there is no right of anticipatory self-defense, is really how far back will they walk, or are they willing to walk the dog? The planes are in the air, they're weaponized, they're crossing your border. Is that close enough? They're approaching your capital. Is that close enough? They're on the landing strip. They're about to take off. You have intelligence a month ahead of time that they're going to do it. How far in advance, how far can you walk the dog back? Obviously, the more imminent, the better the case is for your right to respond ahead of time, and the more remote it is, the more difficulty it is to come up with that requirement. But very simple construct under, in looking at this chart. What you see in red is my attempt to graphically display what Article 39, Article 2, Paragraph 4, and Article 51 describes, and how you translate that to the right of self-defense, the right of anticipatory self-defense, and the rules of engagement terms of hostile act and hostile intent. And then up above in blue, these are examples. So we don't know what a use of force is. We look at Articles 41 and 42, and we feel a little unsatisfied with what it says. So what we have to look at is what have states said is a use of force. What has the Security Council said under its Chapter 7 authority is a use of force or is a threat to international peace and security. And what you see across the top there are some examples of what the Security Council has said or what other states have said is a use of force or is commonly accepted as a use of force or a threat to use force under international law. And then at the very bottom, you'll see, should one of these thresholds be met, what is our authority to respond under international law? So this is kind of intended to be the construct of how we think about things. And we implement, the Department of Defense implements our right of the U.S. right of self-defense in terms of hostile act and hostile intent, and we do so in our rules of engagement. But to try to give you a better sense of those things, we can come up with a series of examples of what clearly might be a use of force, what clearly is not a use of force. There are a number of things that we can discuss. Cyber espionage, is that a use of force, or is that a threat of a use of force? Logic bombs, planted in a bank in Kansas, planted in the U.S. military command and control system. Cyber intrusions that shut down a TV network or shuts down a U.S. warship's communication and computer capabilities. Physical destruction, such as Stuxnet, or digital destruction, where we erase all of the electronic data on Wall Street, for example. When are any of those things a use of force or a threat of use of force? It is a very, very contextual decision. It's very hard in the abstract to simply pick out one simple activity and say, clearly this is a use of force or it is not. We have received over the last 5 or 6 years the constant question, and I know some of my clients are here in the room, the constant question of what is an act of war in cyberspace? I can't decide what I need to do or want to do unless I know what is an act of war. If you look in the UN Charter, you will find the word war twice, once in the preamble and once buried back in Chapter 8 somewhere. Neither of which deals with the use of force and what our authorities are to respond. What you really need to address is what is the use of force and what is a threat of use of force. But that's an abstract, as you get a sense of, which is very, very difficult to put any clear examples for. So what I have always encouraged my clients to do is to simply say, what activities are going on in my networks? What do I want to do in response? What commander do I want to authorize to respond to that? And what authorities do I want to give, what options do I want to give that commander? And that's a very, very difficult question. But what does that set of questions sound like? It sounds like writing the ROE. So to kind of summarize and wrap up at the end of a very quick 20 minutes instead of 8 hours, you know, what should the role of the United States Department of Defense be in defending our nation? That is up to Congress. It is up to the President. When should we engage in activities that's going to defend a network in Kansas or defend Wall Street writ large? It is up to us to put forth a set of rules of engagement to the President for him to decide what is fundamentally a policy question. And that is, as I described those roles and responsibilities for DOD, we protect our own network, we support others in protecting theirs, but at some point in time, the level of pain is going to be high enough that we are going to be shifting to our primary role to defend the United States. The policy question that I would put forth to you to help resolve and to debate publicly is at what point in time, at what level of pain, should the President authorize the Department of Defense to defend the United States by taking affirmative offensive action in cyberspace? And below that threshold, when does the Department of Defense simply support DHS and other departments and agencies in their primary lead and responsibilities?
Thank you, sir. Just to keep our bearings, I'll point out this this last presentation showed how difficult it was for us before there was some written guidance from policy community on cybersecurity, cyber strategy. We didn't have any. Now we have two documents, both very different, and what we do with those we'll discuss later today and tomorrow. And we can take the friendly disagreement on the matter of the so-called response gap as a difference of opinion between the Army and the Marine Corps. The Army always thinks the Marines are a little headstrong, and the Marines think the Army guys are a little shy. So we can reflect on that as we turn to our third and final panelist this morning. And this is to assure you that we're not going to let the lawyers have the only say in this discussion. I'm pleased to introduce my colleague, Professor Christopher J. Eberle, who for the last decade has taught, has been assistant and associate professor of philosophy here at the Naval Academy, where he has taught the core course in ethics during all that time to midshipmen. So we'll hear from the philosophical, moral ethics side in conclusion. Chris took his PhD from the University of Massachusetts Amherst in 1997, and as I said, he's taught here for over a decade. He was a fellow in the Center for the Philosophy of Religion at the University of Notre Dame back in 2004 and 5, and before that a fellow in the very prestigious Pew Evangelical Scholars Program, 1999 to 2000. He's the author of one book currently and two in preparation. His first book, written shortly after arriving here, was Religious Conviction in Liberal Politics, published by Cambridge University Press. And he is now at work on two manuscripts, God, Conscience, and the Profession of Arms, and God and War and Exploration. It's a privilege to have him with us today. Chris.
Great, thanks, George. As you can see, my academic background has prepared me really well for this topic of the ethics of cyber war. Well, I want to thank Ed and Art and the fellows in the center for the past year. You know, most of us were unfamiliar, and Randy, with it, I suppose, is the main exception with many of these issues, certainly the technical side of things. So it's been an education, and it's been fascinating. It raised a series of very interesting questions. And so what I'm hoping I'll do is just lay out some of the main moral questions that hopefully drive our understanding of the law, or should at least shape our understanding of what the law should be. So my main aim is to articulate a set of questions and frame the issue. Having spent a year discussing these issues, I don't even pretend to provide any definitive resolution to these things. Not that there are any definitive resolution to these kinds of issues. And fortunately, since we've had two engaging presentations, I'm going to do the academic thing, and I'm going to read mine. So you'll only have 20 minutes of boredom, but I'll read quickly. And so the pain will be brief. So my aim in this paper is to reflect on a narrow question: under what conditions might a cyber attack provide a just cause for war? In order to answer that question, we need to have a clear understanding of the just cause requirement. So I'll begin by articulating the conception that I favor. And of course, I'll address this issue from a moral and not a legal perspective, and from the the point of view provided by the just war tradition, broadly construed. So, a few comments about the just cause requirement. The just cause requirement is best understood in the light of a bedrock understanding of the moral status of individual human beings. Each has an inherent dignity that grounds a diverse array of natural rights. Most relevant is the claim that each has a right to life, from which it follows that we have a presumptive obligation to refrain from killing any human being. Second, although individuals have an elevated moral standing, they enjoy that standing while belonging to groups that matter a great deal to them. We are inveterately tribal creatures, not merely human beings, but also Christians or Buddhists, Americans or Germans, Ravens or Steelers fans. These communal memberships are often exceedingly important to us. They powerfully shape our priorities, projects, and aspirations. They guide our practical deliberations, and so shape the way we act. Third, just as each human being has a right to life, each human community has a presumptive right not to be attacked with military violence. Correlatively, each community has a defeasible obligation not to employ military violence against any and all others. These rights and obligations form the normative core of an Irenic moral vision implicit in the just war tradition. That is, the ordinary normative condition of the human species is that we are bound together into particular groups, each of which is presumptively prohibited from violently attacking others. Fourth, the just cause requirement performs a distinctive role in determining when that presumption against war is overridden. A just war cannot involve organized violence between just any arbitrary pairing of communities. We may wage war only against a community that singles itself out from among the various possibilities as a legitimate target of military violence here and now. One of the primary functions of the just cause requirement is to mandate that we explain what they have done to make themselves a target of a just war. Fifth, this mandated explanation requires us to identify some relevant moral violation. That is, a violation of the right sort provides a just cause for war. Why? Actions are necessarily correlated with particular agents, and so to correlate just causes with wrongful acts is thereby to associate a just cause with particular agents. There are, of course, many questions to be asked about which kinds of violation can play the required explanatory role and whether cyber attacks can constitute the relevant kind of violation. Before we turn to that set of questions, let me note an epistemic problem distinctive to cyber war. With respect to the use of conventional military violence, the attribution of act to agent is normally unproblematic. When tanks roll over borders, it's normally obvious both that they have done so and whose tanks they are. But this will not always or even normally be the case when aggressors attack with computers, viruses, and logic bombs. Apparently, the sequence of zeros and ones constitutive of a cyber attack can be exceedingly difficult to trace, such that even a technologically sophisticated victim might be unable reliably to attribute the attack to a perpetrator. Mr. Clark talked about that a little bit earlier, and as I'll say in a second, we have a whole panel on that. So, given the conception of the just cause requirement I've sketched, the moral status of an unattributable cyber attack is most perplexing. Although the victims might well harbor strong suspicions, they cannot reliably identify the perpetrator, and so they can't provide the explanation mandated by the just cause requirement. This might not be particularly troubling if attribution is only occasionally problematic, but if cyber attacks are often or ordinarily resistant to attribution, then the just war tradition seems too demanding, permitting us to respond only to cyber attacks perpetrated by the clumsy or the incompetent. Moreover, persistent restraint in the face of unattributable attacks surely provides an incentive for hostile parties to develop and deploy the means to exploit that kind of restraint. Fortunately, I can pass that buck, that whole set of questions, to the next panel. Randy Dipert is sitting right over there. Randy spent the last year beavering away at this issue, and he's promised the seminar and the rest of us, I suppose, that he's going to give us a definitive resolution to the issue today. So
No pressure.
Let me just say that I just mentioned the attribution issue because the issues that I talk about don't seem to be relevant at all unless that issue can be resolved in some satisfactory way. So, in order for the just cause requirement to be satisfied, we must not only be able to specify a violation that pinpoints a legitimate target, but the violation must be particularly egregious. After all, military violence, in its ordinary uses, kills human beings. Human beings have inherent worth or dignity. We may kill human beings only for commensurately weighty reasons, and so we may wage war only in response to violations that threaten very great goods. This basic moral point has important implications for our topic. Even cursory familiarity with the literature reveals that the notion of a cyber attack is used to denote actions that have consequences ranging from the morally trivial to the absolutely devastating. But because only violations that threaten sufficiently great goods can provide a just cause for war, many kinds of cyber attack cannot satisfy the just cause requirement. Let me briefly mention two such cases. One of them has been mentioned before. So one of the main theses of Joel Brenner's recent America the Vulnerable, which we read for our seminar and which I found to be a particularly helpful introduction to these issues. It's full of rich detail about a variety of attacks and exploits, so it's, to me, well worth reading. One of the main theses of his account is the following, that American and European governments are under constant and withering cyber attacks from China, and these attacks reflect government policy, denials notwithstanding. And he describes a dizzying array of those kinds of attacks. So, for example, cyber attackers have apparently been robbing Uncle Sam blind for years. They've stolen valuable information, Google source code, for example, and several terabytes of information about the design and performance of the F-35 Joint Strike Fighter. Brenner suspects that the Chinese have orchestrated many of these cyber attacks as part of a long-term, unrestricted war, the aim of which is to weaken the United States economically and technologically, and thereby to compromise it militarily. To the uninitiated, it's genuinely shocking what these thieves have been able to get away with, and Mr. Clark mentioned that a little bit earlier, and I count myself as among the uninitiated. It was shocking to find out what they've been able to do. The low-intensity campaign waged by the Chinese contrasts in important respects with the cyber war between Estonia and Russia in the spring of 2007. Ostensibly in response to an insult to Russian honor, the Republic of Estonia was, and this is Brenner now, hammered with a distributed denial of service attack from thousands of captive computers organized into botnets. Estonian banks were shut down, remittances from abroad didn't arrive, government departments came to a standstill, big credit card issuers shut down their networks. The attacks directed at the Estonians had some of the characteristics of a conventional war. A perceived injustice, a coordinated response, planned and predictable harm to the ostensible offender, and so on. Unsurprisingly, some perceived a warlike attack. According to the Speaker of the Estonian Parliament, quote, "When I look at a nuclear explosion and the explosion that happened in our country, I see the same thing. Like nuclear radiation, cyber war doesn't make you bleed, but it can destroy everything." Now, it's hardly surprising that an Estonian official would react so strongly to a set of attacks coming from the former Soviet Union. But it's clear that the speaker's reaction was wildly inflated. The Estonians were wrongly attacked, their lives were disrupted, but no one was killed and nothing was destroyed. Human beings are worth far too much to be killed over disrupted access to bank accounts, credit cards, and government departments. So the attacks on Estonia provided no just cause for war. Similarly, with respect to the theft of valuable information, I take it to be obvious that individual cases of cyber theft cannot provide a just cause for war. You can't kill people to prevent them from stealing Google source code, not to prevent performance information about the F-35 from falling into the wrong hands. Similarly, for an orchestrated campaign of cyber theft, pile up the purloined information as high as you like. No accumulation is worth the life of a single human being, and so cannot provide a just cause for war. Of course, this is not to say that economic disruptions or information theft are morally negligible. They might very well permit some kind of robust response, diplomatic protest, sanctions, boycotts, and so on. If this is correct, then the vast majority of cyber attacks can provide no just cause for war. Indeed, because most cyber conflict seems more akin to intense economic conflict than to conventional war, we should assess most cyber conflict with moral principles tailored to boycotts, not bombs. And note one perhaps troubling implication of this general position. You might find it troubling, you might not. If the consequences of waging cyber war are normally comparable to those attending intense economic conflict, then waging cyber war will normally be far easier to justify than waging a conventional war. That is, the clear implication of the claim that most cyber conflict, most of these things called cyber attacks, is morally on par with ordinary economic conflict, is that cyber conflict is far easier to justify than to justify waging war. And here it's important to recall an important component of the moral vision that animates the just war tradition. Although that tradition includes a robust presumption against war, it includes nothing like a presumption against communal conflict generally. Nation states and communities are in constant competition with one another. And as I understand it, the just war tradition is largely silent about economic competition, ideological conflict, diplomatic dispute, even spying and espionage. And it seems to me that there is great moral wisdom in that silence, that you want to segment out war, this particular kind of relationship between states, as being in its own moral category, and separate it out from all these other kinds of competition between communities. If it's clear that many cyber attacks cannot provide a just cause for war, it's no less clear that some can. For better or worse, technologically advanced countries like the United States have become ever more dependent on the internet for the provision of essential social goods. Dependence on the internet is directly correlated to vulnerability to cyber attack. If you can do something with software, Brenner says, someone else can undo it with software, and often they can do it remotely. If an air traffic controller uses software to ensure that planes do not run into one another, and if the network on which the software runs is connected to the internet, then some hostile party might be able to access that software and arrange for the planes to run into rather than to avoid one another. Surely that kind of a cyber attack could provide a just cause for war. Whether the means employed are explosives or sequences of ones and zeros, if some hostile party enacts a plan to crash planes full of harmless civilians, it's very plausible to suppose that we have just cause to respond with military violence. A comparable point applies to destructive attacks on electrical grids, nuclear reactors, and other components of a country's critical infrastructure. Other things equal, it's morally irrelevant whether a power plant or a nuclear reactor is destroyed by a 2,000-pound bomb or by the activation of malware by a keystroke. Of course, as we've already heard a number of times, the experts, the people who know the technical details of these things, disagree about the likelihood of those kinds of sort of very destructive kinds of attacks. The one that Mr. Clark mentioned was the destruction of nuclear centrifuges. It doesn't involve the death of anybody. Let me make 4 brief comments regarding the narrow range of cyber attacks that seem clearly able to provide a just cause for war. First, a cyber attack on critical infrastructure does not by itself provide a just cause. Suppose, for example, that a cyber soldier from another nation state hacks into and is able to gain control over some aspect of our air traffic control system. Assume that his penetration of that system provides him with the capacity to kill large numbers of human beings. But suppose he doesn't do anything like that. His capacity to wreak havoc lies dormant. Surely his penetration does not provide a just cause for war. After all, he might be trying to determine what's possible, or to demonstrate capability, or to deter a stronger enemy, rather than to enact a plan to inflict damage. This first point is closely related to a second. Whether a given violation provides a just cause for war depends upon its role in a wider plan. So, for example, whether the United States had a just cause for war against Japan, 1941, depends upon whether the attack on Pearl Harbor was an utterly bollocksed training run or the initiation of a plan to achieve hegemony in the Pacific. Similarly, for a cyber attack, whether it provides a just cause for war depends on the plan of which it's a component. An attack on the power grid in one small city that's designed to demonstrate mere technical capacity but that accidentally takes out the power grid of a major metropolitan area has a very different moral status than an attack designed to take out that power grid on the major metropolitan area. Despite the fact that the attacks have exactly the same consequences, the permissible response to the first might very well be a demand for compensation. But to the second war, perhaps it depends. Third, there are apparently severe epistemic barriers to identifying the plan served by a cyber attack. I know, George, I don't have to obey that. If we cannot reliably attribute an attack to a specific party, then it seems difficult to determine whether that attack serves any plan, much less what that plan is. Again, the effects of cyber attacks are often unpredictable. So they say, I mean, I don't know, but the folks that we've talked to say that it's very difficult to predict. And so it will be hard to read off a plan from an attack that might very well not have the consequences its perpetrators envision. So uncertainty of attribution and unpredictability of effect complicate assessment of just cause, even in the case of destructive cyber attacks. Fourth, and since I only have 5 minutes left, actually, I'll skip forward and go on to a series of ambiguous cases here. So if most cyber attacks clearly cannot provide a just cause for war, and some can, apparently, then there are many that have a rather ambiguous moral status. And I'll briefly mention 2 or 3. First, what is the moral status of property destruction? When a nation state uses bombs to destroy valuable property, those bombs will very likely also kill human beings. Because the property is valuable, human beings will almost always be located nearby, and so the bombs will destroy the people when they destroy the property. But some cyber attacks destroy property without killing or maiming anyone. Maybe they're really good at doing that. And the Stuxnet virus seems a case in point. My understanding is that it sabotaged extremely valuable centrifuges without mussing the hair on the head of a single human being. This naturally raises the question, is the destruction of property ever a just cause for war? A number of legal theorists, and again, I don't know anything about the law, but we did read a lot of legal stuff this past year. So a number of legal theorists seem to answer in the affirmative. Significant property destruction can constitute an act of armed force that triggers the right to self-defense. Or maybe it's... But then the law of war is more permissive, if so, then the law of war is more permissive than the morality of war. We ought not organize and carry out a plan to kill human beings merely to prevent the destruction of stuff, even valuable stuff. Of course, all bets are off if the destruction of property also kills and maims human beings. If you destroy the respirator on which my life depends, then you aren't just destroying property, you're killing me. And others may deploy lethal violence to protect me to prevent you from doing so. The claim is that the destruction of property as such, non-lethal destruction, does not permit military violence. But even this claim has to be qualified. Property destruction, even its temporary disabling, that triggers a plan that kills human beings, might provide a just cause. Second, what is the moral status of the emplacement of so-called logic bombs? Professor Sharp just briefly mentioned them, and I first ran across them when I read Richard Clarke's book way back when, and still not entirely sure what a logic bomb is, but apparently it does bad things. A logic bomb, well, so and here's my best case, or here's what I understand a logic bomb to be. A logic bomb is a piece of code inserted into a software system that can lie dormant and undetected for extended periods of time, but that can be activated to perform some malicious function. And so, as recently reported, U.S. intelligence agencies discovered logic bombs implanted in our electrical grid that, they say, could be used to destroy infrastructure components. It's all a little bit like magic to me. When my computer breaks, I ask Kathy, who's around here someplace, to say, fix the computer, and she sprinkles holy water on it, and it works again. That's my level of technical sophistication on these issues. So here we go, right? I take it that a cyber attack that actually took down significant elements of the U.S. electrical grid could constitute a just cause for war. It would be sort of like turning off a respirator on lots of citizens. It's the destruction of property that would result in harm and suffering to human beings, maybe death. But what's the moral status of the insertion of code that merely makes such an attack possible? Does that provide a just cause for war? We talked a lot about that in the seminar last year, and here's what I think. After all, I doubt it. After all, there are now a number of nuclear weapons directed at our electrical grid and much else. And they could be activated at the moment's notice. Despite that persistent, dormant, yet easily activated threat, we have no just cause for war against the countries to which they belong. Neither, therefore, would the insertion of logic bombs in our electrical grid by the same countries provide us with a just cause for war. Now, you might think that these two kinds of threat differ in at least one morally relevant respect. The fact that other nation states aim nuclear weapons at us doesn't violate our sovereignty. Their weapons are located somewhere else in the confines of their own country, say. Whereas logic bombs, the logic bombs that threaten our electrical grid, presumably must be located in country. Consequently, the latter are a particularly intrusive kind of threat to which the vulnerable state may respond with proportionate and discriminate military violence. But I find this response unpersuasive. First, I doubt that violations of sovereignty can bear the moral weight this response requires. And second, here I venture out into waters uncharted for myself. The insertion of logic bombs doesn't have to violate sovereignty. No one needs to sneak in to insert a logic bomb, much less force their way in to our country. For it could be the case that our own citizens purchase and use thumb drives some hostile party has infected with the relevant software. We could have our own people bring it in by mistake or unknowingly. And if that's a violation of sovereignty, that's a pretty trivial violation of sovereignty. And it's too trivial to play any role in providing a just cause for war. Third, finally, and ever so briefly, so I think I will get to number 3. Is that right, George?
You
okay? All right. What's the moral status of a state's failure to prevent cyber attacks that emanate from its territory? This is just a whole broad set of issues. I just want to raise the issue. We can chat about it if you want to. Suppose the United States is the victim of a destructive cyber attack that's carried out by hackers who reside in China, but who have not been authorized to do so by the Chinese government. Do we nevertheless have just cause to attack China or respond in any way? There's a large, and I understand, legal literature on this question, and that literature has clear relevance to the moral issues at stake. I gather that it has to do with, you know, the United States response in Afghanistan to the attacks by al-Qaeda, the kind of control that the state has to have over the group in their country. I'm not going to address that in any issue. I'm sure the lawyers will be able to talk more in detail about that. I just want to say that from a moral perspective, this question seems to me to arise in a particularly interesting way for the United States. As I understand it, we Americans are broadly committed to refrain from exercising coercive control over the internet. We believe in internet freedom. We want to give people wide space to do what they want to do with the internet. We want to protect their privacy. And I suppose suppose this commitment to internet freedom is correct. It's the right policy. Morally, so what I mean is it's the morally correct policy. That's the policy we should have. We should give people a lot of freedom to do what they want on the internet. But some citizen misuses his freedom to launch a destructive cyber attack, one that would provide the victim with a just cause or some sufficient reason to respond in some way if it was authorized by our government. But of course, it hasn't been authorized by our government. Might the victim of that attack have sufficient reason or just cause to respond to us, despite the fact that we haven't done anything wrong, right? We have the right policy. It's just the consequences of the right policy are that it gives our citizens, or at least residents in our country, the opportunity to attack people. Well, what are the rights of the recipient of the attack? Let me conclude with one comment. It's not uncommon for advocates of the just war tradition to claim, as I have, that a just war requires a just cause. But this convenience can mislead if understood to imply that the just cause requirement must be satisfied by a single violation. Wars are complicated affairs, and so it's possible that a number of individually insufficient violations might combine to satisfy the just cause requirement. Perhaps we should understand the kinds of cyber attacks I've just mentioned in that way. None of them can by themselves satisfy the just cause requirement, but they can play a role in satisfying that requirement so long as they're complemented by other relevant considerations. It's at least a possibility to consider. Thank you.
Thank you. Okay, folks, our methodology here is we've got about 20 minutes for dialogue amongst the panelists. And I want to open that up, but I do want to point out, Ed instructed me to offer a brief commentary. I'm going to pass on that so we have time for Q&A. But I do want to point out a kind of interesting thing that Colonel Barrett has done in bringing these three together for this initial panel. We have two distinct but related disciplines with fundamentally different methodologies by which they pursue their inquiries. In philosophy, you heard Chris wrestling with what might be called the fundamental principles based on centuries of reflection about things like human rights, the value of human life and versus property, limits on acceptable forms of behavior and treatment of one another, and so forth and so on, that those kinds of resources guide our action in the moral realm. In the legal realm, it's charters, treaties, state practice, precedent, custom, and the tolerated behavior of civilized nations and peoples. So those resources are a different body, but it's certainly a related body of prospects for guidance. And our problem is here, very important. What do we do when those traditional resources seem to us to be either insufficient or insufficiently clear to guide our behavior in some new context involving some new forms of behavior that seem to us to be utterly unfamiliar or novel? Initial reaction, of course, is to panic and to say, well, we don't know what we're doing, all the old rules don't apply, all bets are off, we have to start over, this is a game changer. Then you see what's happening here. I call it the crisis of thin ice. You begin tentatively to step out on further and further away from your comfort zone onto ice that you're not sure will bear your weight. The lawyers call this the search for emerging norms. And it's a very important search. This is what we're engaged in here in these next 2 days in terms of law and ethics. We wonder whether we can extrapolate from those principles of morality or those accepted practices of law to provide through the testing of examples, testing of intuitions. In the case of philosophy, you look at some cases, actual cases, as Michael Walzer does in his famous book, or in hypothetical ones, and try to see what the intuitions of reasonable people and the interpretations by reasonable people in jurisprudence of existing statutes, how far will that take us? So our panel has done a brilliant job of that today, and now our question is, what do we see as those emerging norms? So let's take those questions. Martin.
I wonder if you could, any of you, address a little more extensively the question of anticipatory self-defense. You know, for the last 10 years, we've seen a lot of wrestling with that as a general legal and ethical problem, starting with the Bush 2002 national security strategy, which defined anticipatory self-defense extremely broadly in terms of the risk being so great and the intent being known that we had to take out capability before it had a chance to come to fruition. Is there any analogy to this in the cyber realm? For example, if extensive planning of logic bombs were available such that, if activated, they could shut down a whole lot of things, but they're just sitting there doing nothing at the moment, you're not really too clear about what the intent is for planning all those things, but it couldn't have been good. Why would you have planned it in the first place if you didn't have something in the back of your mind as at least a future attack that you could carry out by these means? At what point would that rise to a sufficient level of threat, and what would be the necessary indicia of intent to rise to the standard of acceptable anticipatory self-defense?
I guess that's something all three of us can address in one way or another. In looking at planning logic bombs, for example, taking in a vacuum the very narrow act of planning a logic bomb on a system somewhere, because you didn't specify where, but planning a logic bomb, is that a use of force? Is that a threat of use of force, which is part of the analysis you have to go through to determine whether or not you have the right of self-defense or anticipatory self-defense. It's a very, very contextual issue. So if you simply ask, is the simple planting of a logic bomb a threat of a use of force, I would say in the abstract, no. But I wouldn't say no in the abstract because it's so absolute. I would say I really have to, the decision makers, the operators, have to have more facts to determine the context of the planting of that logic bomb. You know, is that logic bomb planted in the television networks somewhere, and we have a severe threat of losing cartoons on Saturday? I would say that is not a threat of use of force. Of course, that's an absurd extreme. What if the logic bomb is planted in a government contractor that we rely upon very, very heavily? Is that by itself where the logic bomb could destroy that contractor's ability to support DOD? You know, is that a use of force or a threat of use of force? Do we know who the actor is? Is it a state actor? Is it some teenagers in California? Is it a state proxy actor that's acting on behalf of another country? Is it a hacktivist or a criminal that has some other purpose for doing that? Is it a third country that is trying to implicate, this is one of the James Bond movies, as I recall, from 10 years ago. Is it a third country that's trying to implicate another country to engage in a conflict with the U.S., or for it to appear to be a hostile act against the U.S., so that we would respond? So there are so many factors. I guess the very basic thing, which may not be very satisfactory of an answer because it doesn't give you precise answers, it is all very, very contextual. And you have to look at the issue of what do you know about the planning of that bomb, what is it going to do, or what could it do, and what kind of system is it, and also the greater geopolitical military context. If you think that it is Iran, and they have planted, for example, a logic bomb that's in the command and control system of one of the naval warships that's in the Persian Gulf, and you see troops massing on the border and other things, then you may have a context where you would consider that a demonstration of hostile intent. But on the other hand, if it is something that you can't figure out who planted the logic bomb, or that it was some teenager in Kansas that had done so, is that a hostile act? Well, keep in mind international law addresses, as a general proposition, the behavior and the activities between states, not between a state and its own citizen or a state and the citizen of a third country. But as we have seen since the terrorist attacks, that international law will morph a little bit so that we can use international legal principles that were designed for state-on-state activities to address conflicts with significant non-state actors. So did that help a little bit?
Well, I'm anticipating a situation where somebody pre-positioned a whole lot of logic bombs that, when activated, could basically shut down, say, air defense. And they're just sitting, right? They're not doing it, but you know who did it, right? Would that rise to anticipatory assault?
Well, one of the first things that you would want to do is to clean them off your system since you have found them, and you would have to wonder where else are they. But as Sean said in his presentation, one of the things that in distributing those types of bombs so widely with the death of 1,000 cuts is it's very, very difficult to then determine what the intent is. Is it going to be something that we want to use diplomatic measures or some kind of a protest, go to the UN to object to what has been done? Perhaps use it as a bargaining for some kind of arms control arrangement that Mr. Clark is referring to? Or do we want to take some active measure to prevent that state from activating them? So we may engage in some countermeasure. If you're asking, is it a right, do we have the right of anticipatory self-defense, that is really going to be something in this context that we would turn to the policymakers, to the senior leadership in DOD, who would consult with the National Security Council, not the staff, but the council writ large, and with the president to determine what the president wants to do in response to that set of activities. So there is no clear legal answer that, yes, if it's 48 logic bombs, that's an act of war. If it's not, if it's only 46, then, well, we don't really know what they're doing. It's very, very contextual. And it is a decision of the president. When the Pueblo was attacked, for example, that's an act of war. That is one of the classic examples of an act of war, is an attack on a U.S. warship. Very near and dear to a few of the folks in the audience, okay? An attack on a warship is an act of war, traditionally an act of war. Did we go into war? Was our response an act of war? No. Could we have used force to recover it, or to have some other type of response under international law? Very likely, yes. But did we? It was a political decision not to.
Chris or Sean, do you have anticipatory self-defense? Anything?
Well, I agree that this is a call that has to be made with reference to context, perhaps the location of the bomb, perhaps how many there are, and what potential threat it poses. But there's also the matter of necessity. So self-defense, or an armed attack that gives rise to self-defense, is still bounded by a concept of necessity. So this wouldn't be carte blanche to to launch missiles, perhaps, or to invade an entire country, that states would remain bounded, in most international lawyers' view, by a concept of necessity to do only those things that were necessary to counter that threat. So the first step, obviously, is clean these things off if you have the means to do so. Take steps to prevent them from being reintroduced later. So I think there's a matter of scope of response that has to be considered as well.
There are other questions, so let me go ahead. John?
Yeah, John Calvert,
And Lynn.
Texas Dallas. Be very short. I always turn around and say, what would the other guy do? So what would the Russians do in Estonia? Instead of doing what we say like a cyber war, where it's actually an attack, you take it down to a low-level war of attrition. Well, I would say you take it down even lower, like a war of humiliation, where they go very low-intense, attack legitimacy, authority, control of the society in a systematic, mean, nasty, engineered way, but you don't really reach the level. And I would like to start off with Professor Watson.
Yeah, I think this is exactly what some low-intensity cyber operations strategists have in mind, that they would resort to economic means, they would resort to political means that cause embarrassment to the regime, perhaps undermine its political support domestically, all with a view toward evading some of these acts that can trigger international responses or forceful responses. I do very much have that in mind, and I would agree also with the premise of your question that, you know, what Estonia was or what it is depends on who it's happening to, right? Again, that's what I meant to sort of pose at the end, that the responses to Estonia are probably very different when it's not Estonia and when in fact it's the United States, or as you propose, Russia, that's suffering the same thing.
Herb? Herb Lynn.
I'm Herb Lynn. I submit that the question of a dormant logic bomb is not really the confounding question. The real confounding question to me as a technologist is what happens when you put in a back door that contains no code at all. That is, it's just a hole that you can access, and you have no idea what could be put into it. So there the analogy is like, you know, a hostile nation, or sorry, another nation digs a tunnel under your borders, and they can deliver a bomb, or they can deliver candy and cookies. And that's even, I'd suggest that the question of a hole is even more confounding, and that's likely to be the situation that you're going to face.
Well, so I suppose it's confounding, but I mean, to me, to think about it in terms of the context of war or force or anything like that, I guess my intuitive reaction to these kind of things is the appropriate response to somebody building a tunnel under your border in this context is not to think about it in terms of war at all. Wars and attacks, I just think that that's the wrong frame of reference to employ to think about these things. Just think of it more in terms of economic competition or ideological competition. If they're humiliating you, I suppose, or they're undermining you economically, find some way to respond in a similar way. In the context of somebody building a tunnel under your border, build a tunnel under their border. I mean, thinking of it in terms of war and response, that's just not the right way of thinking about it. To me, if you're vulnerable by this tunnel that's going under, build a tunnel, and they don't know what you're going to do, and you don't know what they're going to do. It doesn't provide either side with the just cause of war, or anything like it.
Sure. So
that would be my reaction.
Another member of the conference here and I have been involved in a project for a few years to try and codify some of this, to produce some sort of guidance on how a group of people who have thought about this envision these rules operating in the cyber context. And it's been difficult, and there have been a lot of disagreements. But one instance that slowed us down for about, as I remember, a couple hours was what happens when you're doing one of these? What are the actual physics of someone either stumbling upon a back door? My understanding is that sometimes you don't even have to do anything, you just have to discover it. This is my understanding of the zero-day defect, perhaps, that it was there all along, you didn't do anything, versus the situation where you go in and you create the back door, which is more akin to tunneling, that you've taken a physical act. And honestly, and we got down to the level where lawyers were asking the technicians in the room, well, what is something being destroyed here? Obviously, that's important for the reasons that Gary and I sketched out. Has property been altered or destroyed or rendered non-functional. And seriously, we got down to the level of, you know, bits and bytes and electrons and ones and zeros changing. That no, every time, I had one technician tell me, every time you enter a system, you're altering ones and zeros at some level, and something is being destroyed. The architecture of those ones and zeros will always be altered for that. And so, gosh, you know, the question, I think, really depends on some very, very granular level peculiarities of the technology. And we couldn't get the room to agree.
Can I ask a question about that? That's sort of interesting. That is, maybe from the law, that's an important question. Like, is there kind of some kind of physical modification? But at least from a moral perspective, that's not really important at all, right? The concern is the threat posed,
or the consequence, right? You're interested in
not whether or not the threat requires you to change a system or not to change a system. It's just, look, I mean, there is this threat, and we can't identify what kind of threat it is. We don't know who does it, what it is, how they got the threat posed, where it came from, the physical manipulation. From a moral perspective, that's not important. But is it important from a legal perspective?
I mean, it is at some level. It's not a particularly American outlook on treaty interpretation, but there's a European tradition that says, hey, look, why did we write this UN Charter in the first place? Maybe the starting point for an interpretation of the Charter is not, you know, did they accidentally forget to check the words between committees? Maybe it's not what effects happen. It's to step back and say, why do we have a UN Charter? What was the big idea here? And is what we're doing consistent with that big idea? Is reinterpreting terms, is claiming to be able to engage in unilateral action always consistent with a treaty that probably at its essence is about giving up the prerogative to unilateral action and surrendering something to a collective security apparatus. I mean, in law, that's about the closest I think where we revert to these bigger level questions, and it's much more frequently done probably on the European continent than here in the United States.
We got time for two more brief ones, please.
So I guess I had a more concrete question than the logic bomb, which is the Stuxnet question. And I'd be interested, because I heard hints of what your responses might be, whether Stuxnet constituted a use of force or an armed attack, if you think they're different things. And would your answer be different if it was the United States, a U.S. nuclear power plant that was the victim?
I would say no, it was an act of sabotage. But then again, if you have a greater political context, if you think that act of sabotage was in some way an introduction to or the beginning of some other larger attack, but by itself, I would say no, it's simply sabotage. You know, if somebody came into the United States and sabotaged one of our nuclear reactors or destroyed it or whatever, it's a criminal act. And we would prosecute the individual if we could catch them. If there was a state, a state sponsorship, then the point that I left off that Sean picked up on was a very, very good one. We have the right of self-defense, but our responses and our actions must be proportionate and discriminate when we respond. So is that act of sabotage something that we believe was a use of force? I mean, I would probably say no, but you're my client, I would ask you. I could tell you as a matter of law, you know, whether or not it was a use of force or we had any precedent in it. And then what would your recommendation be to the Undersecretary of Defense for Policy and to the Secretary of Defense as to what a military response ought to be? Keeping in mind that the military is only one of 7 different major capabilities that the U.S. has in responding to an activity that we are not happy with, or may even be a use of force.
General Sattler, would you like a final word?
Well,
Last one.
you just mentioned the word for the first time, proportionality. You know, in the law of armed conflict, we have great rules of engagement. And the rules of engagement tell us, you know, we can attack based on enemy intent. A little easier to see if someone's setting up a mortar tube, carrying an RPG, and we've taken these to ground very heavily over the last 10 years. But it's always the proportionality piece. We've talked about going to war over an act of cyber infection possibly or whatever. But the proportionality piece, the attack piece, can be machine against machine. It can be, in other words, if I can operate with impunity, there is no deterrence policy. I don't risk anything by probing and interjecting, and if I get caught, I back off. When we get to that point where that becomes more than just a nuisance, how about the proportionality piece, being able to go back to tell the young cyber warriors that we're training when they're at their machine defending, if we have these attack tools, when can they use them, and what does proportionality mean in the cyber, I'll use the word domain, although I think Mr. Clark doesn't particularly care for it. What does proportionality mean?
I mean, at least just intuitively, my sense would be that's a kind of a tit for tat kind of a thing, if they build a tunnel under, that threatens you, you build a tunnel back. We're not talking about the killing of people in this case, right? So the kind of moral barriers to responding in kind are much lower, I think, right? So if somebody raises their, I think if somebody raises their taxes on you, or they put a tariff on a certain product of yours, put a competing tariff back that hurts them roughly the same amount or a little bit more, right? If we're talking about cyber attacks that are these little pinprick type things, I just think, just hit them back pretty much the same way, maybe a little bit more to get that, to deter them from doing it again. If that's the kind of conflict between communities we're talking about, tit for tat seems like a good idea to me. Tit for tat is a little bit more.
Well, we're out of time. Go ahead.
Just make one
Yes.
quick point. Under international law, proportionality does not require tit for tat. It may be the decision for moral reasons or ethical reasons or for other reasons that we would not respond, but proportionality under international law does not require a in-kind or a tit-for-tat response. General Powell said during the first Persian Gulf War that, and Secretary Cheney as well, said that we would engage in overwhelming and devastating use of force against Iran if they were to use a chemical or biological weapon on the battlefield. Clearly not a proportionate or a tit-for-tat type of U.S. government approach.
General Sattler has a presentation for our panelists, and we want to wrap things up and thank them now. So, sir.
On behalf of Eberle Miller, Dr. Watts, thanks a lot for the great comments. Colonel Sharp, thank you. Always a pleasure. Good to see you again, sir. Dr. Eberle, thank you very much.